Good evening, everybody. This is unbelievably the 16th Hugh Laddie lecture. Halfway through the next volume when we're going to do on the 20th. Tonight we have a speaker who is not a judge, who is not a fighting lawyer. Indeed, his main job is not even being a lawyer anymore. He represents 5 million creators. I don't really understand what job he does. He will tell you, he probably does. Hope he does, really. Because I've never had much to do with these mighty organizations. Worst was ever sort of holding a brief for the PRS once or twice, but that's about it. So Gadi has very kindly come over from Paris, where he tells me his French is absolutely awful, so he speaks English, which they can understand, which is more than the English can do in speaking to the French. And without any more, no looking at your phones. It's half time, and it stays half time until after questions are over. Gadi, you're on your way.
Thank you, Sir Robin. It is a pleasure to be here, and I'm extremely honored to give this lecture. Before I start, I'll mention that I had the pleasure of having a very brief meeting with Sir Hugh Laddie when I was a student here at the University of London. It was more than 20 years ago. And it was a short meeting, but I remember it very well because when I started my career in private practice, I worked a lot with his book on copyright, Laddie, Prescott, and Vittoria. And we used to quote very frequently from this book in court documents. So meeting him in person was a very special and very memorable moment for me. And I remember meeting a humble, very friendly, a lovely man. So it's indeed a great honor to give this lecture in his memory, and thank you again, Sir Robin, for reaching out to me and for inviting me to give the lecture this year. I have to confess that the choice of topic for this lecture was not a particularly difficult task, because every intellectual property conference and every copyright event these days is on artificial intelligence. You can hardly avoid this topic. But despite the fact that this is an issue, or AI, or artificial intelligence is an issue that's on everyone's agenda, the link with collective management of rights is not something that I've seen discussed or debated publicly. So it was a fairly easy choice for me as a topic for today, because it has very practical and very important implications. It has very practical and very important implications because the global collective management system is in charge of collecting and distributing a very significant part of the creative industry's revenues. So for authors and publishers, we are talking about, in US dollars, it will be more than 13 billion. For record producers, it is another 2.5 to 3 billion. For performing artists, another billion. So overall, this system is in charge of at least 16 to 17 billion US dollars annually. And therefore, the way in which this system will eventually develop and adjust to dealing with artificial intelligence will have profound impact on the financial health of the creative industries generally, on the profitability of many companies, and on the livelihoods of millions of individuals. So millions of creators, but not just, also many individuals who work in the music, film, and other creative industries. Now, I had a look at the list, I should say the long and very impressive list of past speakers of the Laddie lecture, and I've noticed that most of them, as you mentioned, Sir Robin, most of them came from the judiciary or academia. But because I come from the industry, what I thought I will do today is share with you the industry's perspective and explain how we are dealing with the issues raised by AI, how we are trying to answer all the difficult questions that we are facing, what are the practical solutions that we are developing, and a little bit about the message that we give to policymakers on this important issue. Now, I'm sure it will not come as a surprise to any of you that the quick development of AI, especially in the last year or two, raises many concerns for our sector, for the creative sector. And I'm sure most of you will be familiar with at least some of the services that we are talking about, but just to set the scene. So we have the AI systems that can create texts, and therefore they can create, I guess, in addition to student papers, also song lyrics, articles, scripts, stories, and of course that's ChatGPT, but also many others. We have the AI systems that can create images and visual art based on text prompts like DALL-E or Midjourney and others. We have systems that can compose music with or without lyrics. I think the most popular one now is Suno, but of course there are others. And finally, we start having more and more systems that can create videos or audiovisual content based on text prompts. I think the leading one now is Sora, but again, there are others. And I thought I'll just mention that in the opening because it is important to emphasize that we have now AI services that affect every repertoire and every part of the creative industries. But it's also important to remember that not all AI systems are alike. There are different types of AI systems, and many of them have been in use by the industry for a long time. And so broadly speaking, we separate between the generative AI and the non-generative AI systems. The generative AI systems will be all the ones that replace human input and control. The generative AI systems decide on the output. The output can be based on a human prompt, but ultimately the person using these systems does not have control over the creative process or the final creative expression. And I think for me, the best illustration of that is that you can enter the same prompt, the exact same prompt into DALL-E, and each time you press enter, you will get different results. You'll get different images for the exact same prompt. So to me, it always looks a little bit like these slot machines in the casino. You insert the same coin, you pull the handle in the same way, but the result will be different. You will never be able to know the result or the outcome in advance. The non-generative AI systems are different. These are all the tools that are operated by humans, where the human controls and dictates the output. And within the creative industries, these non-generative AI systems have been in use for a long time. They've been in use to improve, to simplify, and to accelerate the creative process. So for example, in the music sector, we have programs or software that are used by songwriters to write new songs. We have programs that performing artists are using to fine-tune their voice, programs that can add new instruments or new voices to existing recordings. We have programs that studio engineers are using to clean up audio tracks. All of these sort of programs and services that were used to create and to release the new Beatles song 45 years after the original demo was recorded. By the way, these systems exist also in other sectors. So in the audiovisual sector, we have programs that do color corrections, aging or de-aging of actors. Film studios have been using AI to remove, for example, freckles or blemishes from the face of an actor. And with the AI, they can do it once, and the system will run through the whole film and correct everything instead of a human doing it manually frame by frame, as it was until not too long ago. So all of these non-generative AI systems are not necessarily new. they influence the output of the creative process, but the element of human control exists. We don't have the randomness or the unpredictability that we have with the generative AI systems. And the non-generative AI does not replace human creativity. And when an author uses these tools, the creative choice belongs to the author. And the outcome reflects the author's taste and the author's personality. And just to share with you something very interesting, so in France and Germany, there was a recent study by the authors' societies there, SACEM and GEMA. They did together a study, and that study or survey revealed that already 35% of the creators who were surveyed said that they've been using AI to help them create music. 35%. And maybe not surprisingly, the younger the creator, the more likely it is that they will use AI. So in the age group of the under 35 years old, more than half of the creators said that they've been using AI to write music. So we have this distinction between the generative AI and the non-generative AI tools, and this distinction is extremely important because based on that, when we look at the output, we separate between the AI-generated works and the AI-assisted works. The AI-generated works, meaning all the works that were entirely machine-made, and the AI-assisted works where there was human involvement and human control. And the way collective management organizations deal with each one of these categories is very different, as we will see in a couple of minutes. But maybe that's a good moment to pause and say a few words about the collective management world for those of you who may not be very familiar with it. So as far as authors' collective management is concerned, and Robin mentioned earlier the figure of 5 million authors and rights holders. So today for the authors part of the industry, for authors and publishers, we have 227 societies, 227 collective management organizations or author societies. It's different terminology to describe the same thing. And these 227 societies operate in nearly 120 countries. They all belong to the international organization that I'm heading, that's headquartered in Paris. And yes, they represent more than 5 million authors and rights holders, so normally publishers. And they collect on their behalf, as I mentioned earlier, in US dollars, about 13 billion every year. Now, it's common to think that collective management exists only in the area of music, but actually we have societies managing rights in other repertoires. So we have societies dealing with audiovisual repertoire, and they represent film directors and screenwriters and TV directors and screenwriters. We have societies dealing with literature, dramatic works, and of course, visual art. So paintings, sculptures, photographs, digital media, and many others. The main concern of all of these societies, and of course of all of the authors they represent, is that in the long term, generative AI works will replace and will substitute the works of human creators. But the more immediate questions that we need to address on a practical level and on a day-to-day basis are the following two. The first one is, how do we deal with the use of copyright works by AI? How can we license all of these AI companies who ingest copyright works into their systems? I can share with you that as of today, no AI service is licensed by author societies, not a single one. But I think it's very clear that all of them are using copyright works that were created by humans. None of them has a license. That's the first issue. How do we license all of them? The second issue is, and I think it's no less important, is how do we handle, how does that system, this network of collective management of rights, going to handle the output of these services? To what extent we can bring the AI-generated and the AI-assisted works under the umbrella of the existing collective management framework. Do we treat these works as normal works? Do we license them like any other creative work? Do we need to ask ourselves if there's copyright in these works? And if there is copyright, who owns it? How do we distinguish between works that were entirely computer-generated to those that have some degree of human input? All of these are very practical questions, very important questions. I will try to answer them, but before I do, I want to start with one observation. And that observation has to do with the way in which the industry reacts to AI. The way the industry responds to this new technology is very different to the last time there was such a major shift in technology. And I think some of you will remember this. The last time we had a major change in technology was in the mid-90s when we started to have digitization and online use. In those years, when the internet became fast enough and sophisticated enough to allow the transmission of music files and video files, we started to see websites offering unlicensed content, first for download, and very shortly after that, we had the peer-to-peer file sharing networks like Kazaa or Napster or the Pirate Bay. The way the industry reacted to that was to try and stop these activities. They tried, mainly the record labels and the film studios, to control and to prevent the use of this technology. They sued the operators of these platforms, and in many jurisdictions also brought litigation against the individuals who were using these platforms. The industry certainly didn't try to license these services, not at the beginning and not for a very long time. In fact, for a long time, the record labels resisted licensing the streaming services that emerged as an alternative to these illegal platforms, services like Deezer or Spotify. Today, the approach is very different. I don't see any record label executive saying that we need to stop AI. On the contrary, everyone is talking about licensing. Everyone is saying that we need to find a way to license these services. You see CEOs engaging with this new technology. You see them engaging with AI companies. And I personally believe that is very positive. And it's generally setting the tone for things to come and for how the industry is going to deal with this issue. So against this backdrop and with this observation, let's start to examine the main issues the industry is facing and is struggling with. And I'll start with the use of copyright works by AI machines. Look, author societies want to license the copyright works that they administer to AI companies. They want to license. But in order to do that, they need to know which AI companies, which works they are using, how exactly they are using them, and where they are sourced from. We don't have that information. In order to get answers to all of these questions, we need the AI platforms to provide information. Which is why transparency is so important to us. Transparency is one of the industry's biggest asks from decision makers today. When we are lobbying governments and legislators on the issue of AI, one of our key messages is that we need transparency obligations for AI operators. Now, probably the biggest lobbying achievement of our sector so far is the new EU AI Act, which was adopted in March. The Act requires AI services to publish, and I quote, a sufficiently detailed summary of the content used for training of the platform. Now, this is very early days. A lot will depend on how this is going to be implemented by EU member states. And also, this sort of obligation doesn't exist outside the EU. I'm not aware of any other country or any other jurisdiction where this obligation exists. But it's a good start. It's a very important principle for the industry and something that our sector pushed very strongly for. And now also there's the new European AI Office. And one of its roles and responsibilities, it's a new entity, but one of its responsibilities will be to formulate the rules and the template for disclosure of information by AI services. By the way, in the absence of transparency, what we see now in the market is more and more companies that are trying to develop services to help the industry identify its content. And I get approached by many of these companies. I've seen some demonstrations. Some of them are quite impressive, actually. One of these companies claims that they can identify which songs were used to create new AI music. There's another company that can extract the original work from the AI service. So you can give them the original work, the original text, for example, if you wrote an article, and they can prove to you if that article was scanned by the AI company, the relevant AI company or not. So essentially, they specialize in finding whether with the correct prompt, they can get the AI service to spit out your work, your original work. Very, very interesting and very impressive. But of course, all of these companies, they're trying to build a business around a problem that the industry is facing, that we need to know who to license and what for. And that problem, it would be best served and best solved in voluntary agreements between rights holders and AI companies, which, as I mentioned, don't really exist at the moment. They're in the very early stages. Or another way to solve this problem would be with transparency obligations in applicable laws. Now, assuming we have all the information we need in order to issue a license, the general view is that we are talking about a license that covers at least the right of reproduction, the right to make copies of the work. We know that copying is part of the machine learning process or the AI training process. The terminology used to describe that is text and data mining. It is not copying in the traditional sense. It is copying for the purposes of generating data sets that are later retained and retrievable by the AI company, and also that are integrated and merged into other data sets that come from other copyright works. Now, of course, copying or reproduction is an act that is restricted by copyright, for which authorization is required from the rights holders. So all of the societies who hold this right, either by way of an assignment or another mandate from the rights holders, they are in a position to license AI companies. But in some jurisdictions and in some countries, you find exceptions. There are exceptions that apply, and that may mean that the AI services do not need a license to engage in text and data mining. Now, exceptions generally depend on where you are in the world. This is not something new in copyright. But it's crucial. I cannot even emphasize how much it is crucial when it comes to AI, because it starts to shape the way and the direction this industry is going. So, for example, in Japan, there's a very broad exception for text and data mining from 2009 that allows text and data mining for any purpose, both commercial and non-commercial. And I already hear that when societies approach services in Europe and ask them to get a license, they say, well, but we do our mining in Japan. In Singapore, there's an exception. In the US, of course, we have the fair use exception. I'm not going to go into that. I don't think it's very clear whether machine learning is fair use, and it's definitely a topic that can occupy a separate and complete lecture, but anyway, fair use is something that is decided on a case-by-case basis. Here in the UK, there was a proposal for a very wide exception for text and data mining. It was met with very strong opposition from the industry, and it was eventually dropped. And in the EU, there is an exception. There is an exception in Article 4 of the Copyright in the Digital Single Market Directive. It is very broad. It permits text and data mining, but, and there's a big but there, it applies only when the use has not been expressly reserved by the rights holders. So you can, under EU law, you can engage in text and data mining. If you're an AI company or an AI service, you can engage in text and data mining unless the rights holders said that you can't. Which brings us to the very important issue of opt-outs. So rights holders under EU law can reserve their rights. They can opt out of the exception. And I had some discussions recently with lawyers from the technology sector, lawyers who represent AI companies. I also heard some of them speak at different public events and conferences. And I heard them say that the industry is more or less settling now on the idea of reservation of rights, meaning that if you're a copyright holder and you don't want your works to be fed into AI machines, you need to proactively reserve your rights, which raises a lot of practical problems. There's also a big question around the more theoretical and philosophical issue of whether it is appropriate to shift the burden in such a way to rights holders. But even if we ignore that problem and we just look at the practical issues, the practical problems that we are facing. Problem number one, how are we going to do that exactly? How are we going to opt out? So for example, to block ChatGPT from scanning your website, you need to configure your website in a certain way and enter a specific prompt that excludes the chatbot of OpenAI, the company that runs ChatGPT. Now, does that mean that copyright owners need, from now on, to constantly monitor the markets to find out which AI services are possibly using their works and how they can opt out from each and every one of them? Let's say you're the Guardian or the New York Times. You don't want ChatGPT to scan your website. So you do what needs to be done, you change the configuration, and you make sure that this prompt is there to block ChatGPT. But what do you do if you're a photographer and you don't have a website and hundreds of your photos are circulating online? How do you stop them from being fed into AI services? Problem number two. Is there really an effective way to know that the opt-out was respected by AI companies? Problem number three. If my works were already scanned and mined before I submitted my opt-out, does it mean that I missed the train? Or are these AI companies now going to be obliged to extract all the data that came from me? Can they even do that? Can they even do that after they merge the data that came from me with other data that came from other people? Let's think of a company, an AI company that's based in the EU. There was a period when they worked with no regulation around them. During that time, it wasn't really clear what was allowed and what wasn't. Then we had in 2019 the directive with the exception for text and data mining. And then earlier this year in March, we had the new EU AI Act with all of these additional rules. So if rights holders opt out now, does that mean that what the AI companies did potentially legally in the past should now be reversed? There's lots of questions, there's lots of uncertainty around these issues. What I'll try to do now is to share with you how societies, author societies are dealing with that, how they respond to this. So the first thing they do is to review the scope of the mandates they have from their affiliates, from the creators and the publishers. And they want to make sure that they can reserve rights with respect to text and data mining and that they can opt out on behalf of their affiliates. And if needed, they contact the creators and the publishers and they ask them to sign new membership forms that specifically allow the society to make these reservation of rights. Some societies are doing it more generally, so they just amend their bylaws in a way that would allow the society to opt out on behalf of all of its affiliates. They adopt them at the General Assembly, and with those new bylaws, they're in a position to reserve rights and opt out. So the first thing societies are doing is to make sure that they're in a position to reserve rights on behalf of all of their members. And the second thing they do is, of course, to make these reservation of rights, to make these opt-outs, and you can see some examples on the screen from France, Germany, Denmark. Many, many other societies made these statements about reservation of rights. I know that many of them did not stop at making these reservations and actually issued letters to hundreds of AI companies to put them on notice that they reserve their rights and to invite them to negotiate licenses. And finally, another thing that societies are doing is to take steps to ensure that the licenses they issued to digital services like Spotify, for example, cannot be interpreted as covering AI users. So what they do is they include a specific prohibition in these licenses against using the license to generate AI works. And in other words, they want to make sure that no third-party AI company will be able to claim that a license that a music society issued to, let's say, Amazon or Apple or Spotify allowed AI platforms to scan Spotify and turn all the songs there into datasets. Now, before finishing on this point of the use of copyright works for AI and for machine learning, I'd just like to mention one thing which is very important, and that is that not all authors will want their works to be licensed to AI services. So unlike record companies who may be more open to the idea of licensing AI services, some authors simply don't want their works to be used for machine learning and to train AI platforms. And so they want to opt out, not in order to be able to license them to receive royalties. They want to opt out because they don't want AI services to use their works. And I wanted to mention that because this is also something that the authors' societies will have to deal with, and also explains why transparency, reporting, and accountability by AI companies is so important to us. Not all repertoire will be available to license for AI use. So, perhaps even more challenging is the question of how authors' societies should deal with all of the products that come out of AI services. And specifically, whether we can bring all of these products under the umbrella of the collective management framework. To answer this question, we first need to establish whether these works are protected under copyright. And in order to know if they are protected under copyright, we need to know if there's an author for the work. Because if there's no author, there's no copyright, and if there's no copyright, there's nothing to collectively manage and nothing to license. I guess most of you here would be familiar with this case of the monkey who grabbed the camera from a wildlife photographer and took some selfies, and the court ruled that there's no copyright in these works or these photos because there's no human author, and because the photos were not the output or the outcome of a human intellectual activity. This all makes sense, and it sounds easy in theory, but in practice, it is very difficult to adopt and to apply this line of thinking to AI. Because AI-generated text, images, music, videos, they are based on human prompts. It can be a one-off, very short prompt. It can be an exercise that involves hundreds or thousands of prompts. So how much human input is needed for us to say that there's copyright in the work? And can prompts by themselves be considered sufficient human input? So if you think of all of the possible scenarios, on one end of the spectrum, we have works that are 100% created by a human author. On the other end of the spectrum, we have those works that had no human involvement whatsoever in their creation and were entirely generated by AI. But in between, there are many situations where there was a certain degree of human involvement, a certain degree of human intervention, and where the author used an AI tool or directed the AI to assist, to assist in the creative process. So what is the degree of human involvement that is required for us to say that the work is a work of human authorship and therefore can be protected and can be licensed? I think this is one of the most difficult questions that we are facing today. And so far, there's not a lot of judicial guidance on this. But from the little we have, it seems that the general direction is that prompts are not enough. Merely prompting an AI service to produce a work is not something that entitles the person to copyright protection. This was decided, I think, in one of the first rulings of the US Copyright Office on this issue. It was the case of Thaler versus Perlmutter. It was an artwork that was submitted for registration by an applicant who actually declared that it was not him, but by his creativity machine. So the applicant themselves stated that there was no human intervention. And the US Copyright Office refused to register the work and said that because the work was entirely generated by AI, it lacked the human authorship that was needed for copyright protection. And this was affirmed by the district court. I think it's still on appeal. The same principle, by the way, was adopted recently in another ruling in the Czech Republic by the Municipal Court of Prague, where a person claimed that he has copyright in a work that was generated by DALL-E, but the court said that this person cannot be considered the author of the work, and there was no copyright there. So what the US Copyright Office and also what the Czech courts did was really to ask themselves two questions. How much human input was there, and whether it was the human who dictated the expressive outcome. And when it's just prompts, it's not the human, but the machine who decides about the output, and therefore there's no human authorship and no copyright protection. And it seems easy, but it gets much more complicated than that. And when I saw some of the other examples that I'm going to share with you, I kept thinking how they would apply to other repertoires like music. So in the other example you see on the screen, this comics book or the graphic novel Zarya of the Dawn, it was AI tools that were used to generate the images, but the author added the text and arranged the text and the images. So what the US Copyright Office did here was to separate between the elements and to say, okay, the human contribution here was limited to the text and to the arrangement, so we recognize copyright in those, but we refuse to recognize copyright in all of the images because it was the AI that generated them, and therefore they were created in an unpredictable way and with no real control of the author. So in this example, you could separate between the different elements of the work, but what do you do with music? Can you separate between the drums and the bass line when the drums were played by a human and the bass line came from the AI? And I think actually in most cases that involve AI, it gets much more complicated than that, and we don't really have the ability to distinguish between what is AI and what is human in the work. And this is where I believe that there's a big gap, a huge gap between theory and practice. And I will explain my point using two other examples from the rulings of the US Copyright Office. The first one on the top there, the Théâtre d'Opéra Spatial. This is an image that was generated by Midjourney, but the author said that there was a lot of human contribution. He said, I prompted Midjourney 642 times. I used other software to edit this image. But he could not distinguish between the AI and the non-AI parts. And he could not disclaim the AI-generated part. So the work as a whole was rejected from registration as a copyright work. And in what I believe is the most recent ruling, the picture that you see at the bottom there, Suryast, the author used an AI tool to blend a photograph that he took with the famous painting of Van Gogh, the Starry Night. And here the US Copyright Office concluded that there was no copyright in the work because it was the AI and not the person who claimed authorship that was responsible for the final expressive elements. and the person who applied for registration had no control over how these elements will appear in the final output, in the final product. So, look, I mean, when you read these decisions, they're all important, they're all valuable, they all make a lot of sense, but applying their conclusions in practice and using them for other repertoires like music is quite complicated and problematic. And when you think about these things or these decisions from the point of view of entities whose role is to manage rights, the value of these rulings, in my opinion, is very limited. Because societies cannot really identify and cannot draw a line between the human part and the AI part. When dealing with collective management entities are dealing with works that are submitted for registration, they have a very limited ability to review them and to evaluate them. They cannot decide if the works were used by or were created by an author or if AI software was used. And if the author did use AI, the society has no way of finding out how much. They cannot identify if it was 50% human input and 50% AI, or maybe 90% and 10%. And they certainly cannot distinguish between the AI and the non-AI parts. As far as I know, there's no technology available today that can reverse engineer a work and separate between the human and the non-human contributions. I know, by the way, that there are some companies that are working on developing such tools. I've seen some demonstrations. There's at least one company that I saw that today can identify if a song is 100% AI generated. So with a very high degree of accuracy, they can tell you if a song came out of an AI service. I saw it. It's quite impressive, but I'm yet to see a company that can tell you that a song is 30% human and 70% AI. And even if there was such a technology, it is very difficult to see how a society, an author society, can make a determination as to whether too much AI was used and to deny registration based on that. So how much is too much AI? 30%? 51? 90? So for me, and I'm sharing my personal view, and I'll emphasize it, it's not the views of CISAC, not the views of author societies, at least not now and not formally. But in my opinion, anything on the spectrum that's between 0% AI, so 100% human work, and possibly 99% AI, practically has to be treated in the same way. And in my opinion, as long as there is some human input and some degree of human control of the output, even if it is minimal, we should view AI as a tool in the hands of the human creator, at least for the purposes of rights management. We simply have no other choice. We cannot separate between the human input and the non-human input. And so, practically what societies are doing today, and let me share with you how societies are dealing with this issue. The first thing they're doing is to ask for declarations. When author societies receive registration requests from their members, they have a registration process. So they ask the authors to submit information. And when an author presents a new work for registration, at the stage of documentation, when the work is added to the collecting society's database, it's all done on the basis of a declaration from the author. Societies always ask for a declaration that it was the author who created the work. And more societies now started to ask the authors, when they submit works for registration, they ask them to declare that it was not created by AI and is not the result of just prompting an AI service. And when the work was created by AI, and the person who submits the work provided just the prompts, and the society knows that, they will not accept the work for registration. Another thing that societies are doing is to see if there's been any change in the registration pattern. So they started looking at the number of registrations by an affiliate to see if there's been any noticeable change. So if an author used to write and used to submit 70 songs a year, and suddenly they submit 500 a month, this will raise a flag. And I've heard stories about songwriters who submitted almost nothing, or moved from submitting almost nothing to submitting thousands of songs every month. So of course, the societies will stop that and ask for explanations. Now, the more sophisticated and the more advanced societies that also require their authors to submit copies of the works, they started to apply tools that identify patterns or variations. So if they see, for example, that there are many registrations of more or less the same work with only minor variations, they will again stop that and they will contact the author and will ask for explanations. And so with that, I will move to the concluding part of my presentation on the future of the collective management system. And I would like to finish by bringing all of these elements together and trying to reach some conclusions about how AI will affect the existing framework for collective management of rights. When the idea of collective management was born, it came out of the understanding that the collective is stronger than the individual. In 1888, in the center of Paris, when the French author Beaumarchais brought a group of playwrights together, they all understood that if they negotiated together with the Comédie Française, they will be able to obtain better terms. They will be able to negotiate better contracts for the use of their works. In 1851, when the first Author Society for Music Composers was established, also in Paris, it was created to solve practical problems that human creators faced in managing their rights. Problems like identifying who's using them, negotiating licenses, collecting fees, enforcing rights against unauthorized use. And with each technological development, these benefits of the collective management system only grew stronger. And it was most evident with digital technologies. The economies of scale that the collective management system offers, the economies of scale became much more important in the digital markets. The ability to process data, to negotiate with digital platforms, some of the biggest companies in the world today, to claim rights and repertoire, to collect and to distribute royalties. These are activities that the individual author cannot do. It's simply impossible for the individual rights holder to do those. The revolution that AI brings and will bring will only create more data, more services to license, more ways to exploit copyright works, probably many ways that we cannot even anticipate today, and much more repertoire that will be produced and need to be managed. Also, there'll be a range of new activities that will be easier to handle collectively and that did not exist before, like all of this reservation of rights that I mentioned earlier. I also think that we will see much more litigation about, for example, how rights were used, how opt-outs were made, whether opt-outs were respected or not. So it's easy to see how the raison d'etre of collective management will continue to exist. What we can definitely expect is for the collective management system to evolve. It will once again have to adjust to a new market reality, but the benefits of economies of scale in collective rights management, these benefits will, in my opinion, continue to exist and continue to remain valid, possibly even stronger than before. So I'll conclude with that. I have no doubt that we are only at the beginning and that artificial intelligence will bring a tectonic change to the world of culture and art. But art has and will always be based on human emotions, human experiences, and no machine will be able to replace that. The famous French impressionist painter Paul Cézanne is quoted as saying that a work of art which did not begin in emotion is not art at all. And along the same lines, I want to share with you a nice example that I'm actually borrowing from a friend of mine, Ricardo Gomez, who works for collective management in Spain. And he said, if I go to the opera to listen to a live performance of Rigoletto, if I go to see a live rendition of Rigoletto, and during the performance, the soprano reaches a very high, almost impossible note. As humans, we will feel something. We will react. Our bodies will react. We may have some tears in our eyes, maybe goosebumps on our skin. But if when we enter the concert, at the entrance to the opera house, there will be a notice. And that notice will say that during the performance, when this special note comes, what you will hear is a sound generated by a computer that is superimposed on the soprano's voice. It will create no emotion. None. And it will not matter if we will have experts assuring us that this is exactly the same as the human voice. It will not matter. We will not react in the same way. So I don't think there's any risk of machine-made art replacing human art, as long as we know what we are listening to, and as long as we know what we are watching. So what we need to do is to promote transparency towards the rights holders, so that they can get paid when their works are used, and they can decide if they want their works to be used or not by AI. And also transparency towards the public, so that we know if what we are listening to is a computer or a human creation. And we need to make sure that human art is paid for, like we did with all the previous technological developments that threatened existing remuneration models. And I believe that the collective management system will play a very big role in supporting this and in making it happen. Thank you.
I said this was the 16th Hugh Laddie lecture, but I think it has had more questions asked and unresolved than all the 15 that have gone before. It was a towering lecture. Thank you very much indeed. Let's have another. Before we proceed across the road, and by the way, keep your badges on. We have security, and sometimes we have a nightly demo. We have a plan B as well, but you need your badge, or you won't get to the North Cloister. But before we go, Gadi has kindly said he will answer questions. So far, he hasn't answered any.
That's not fair. I can do it again.
But we've got a mic roving around somewhere. And questions or comments? Please say your name.
Thanks. Matt Harvey. You mentioned that it may be inevitable that a collecting society has to recognize a work which is up to 99% AI generated, or the contribution was from an AI. I think that will have an impact on what is regarded as an author, and I think it will have an impact on the economics of a creative industry, whether two different kinds of works have equal monopoly rights or quasi-monopoly rights, and the prices they command. You used two terms for this segment of the industry. One was collective rights management, but the other was author societies. Do you think these entities have duties in any way to protect what it means to be an author and to promote their overall economic interests in the light of AI?
Yes. First of all, when I use the terms, I use them to describe the same thing, at least as far as the CISAC societies are concerned. So I think the difference is that author societies only deal with authors, and publishers and collective management organizations can be used to describe others, like the ones that manage the rights of record companies or performers. Absolutely, the ones who represent authors have a duty to protect authorship. But what I try to describe is a very practical issue. Today, the system is based on submissions from authors. Those submissions include the name of the work, the name of the author, shares if there was more than one. How can you distinguish on that basis between different types of works? I don't think we have any practical way to police to what extent AI was used to create a work. So it's all based on declarations and all of the other measures that I mentioned. But absolutely, I think one of the biggest challenges of author societies today is to protect the interests of the human authors. And again, not to add more questions to the debate, but I cannot stop thinking how the world would look like if there is a parallel world of unprotected content that was created by generative AI systems that is not paid for and competes with human works. And already when I play Spotify and I let Spotify choose the playlist, every 3 or 4 songs I ask myself if what I'm listening to is a human work, an artist, a real artist, or an AI-generated work that was pushed to me so that no royalties will have to be paid. I think that's a real problem that we are facing. What I was trying to, the point I was trying to deliver is that I think that as long as there is some degree of human involvement, I think that should be sufficient. And I think, again, and I will add one more sentence because that could be a topic for another lecture, I think that we will be forced at some point to revisit, as AI develops, to revisit the idea-expression dichotomy in copyright law. Because how long will it take before we will be forced to think if the idea was developed enough to justify copyright protection? I think AI will push the limits on this issue, but it's really early days.
Yes.
Thanks, Gadi. Crispin Hunt. I'm a songwriter. If, as you said, that it's possible for some AI companies to show the provenance of a new work that they've created, so they can identify, say, the songs that went into creating a new AI song, if then you had, an AI work being registered with the CMO that was 99% AI created, but we were giving the copyright to the new creator, would we then, hopefully, if those kind of technologies develop, would we then be able to also credit and pay all of the other creators whose work was used to collage, something masquerading as the future? Because in my understanding, that company that can show the provenance of a new song, in fact, it's not that there are millions of songs going into every new creation. In fact, the number is quite dealable with. It's in the tens of authors. So you would be able to identify the original work that has then been chopped up and collaged into a new work. And so would you have to treat that in the same way as some collecting societies treat samples and pay the original performers on the samples?
I'm not sure I completely understood the question, but I
So
think the point is that I'm not sure you will get to that situation because author societies will not receive registration from AI companies. So you need to be an author to submit.
No, but if the author has submitted a work and we give the author a work that was 99% AI created, but we still give it we register it and we'll pay him, would we also pay the 99 other creators whose work was collaged to make the 99% of his work that was AI?
Right.
But if the technology can identify those authors,
Yeah.
which apparently it can.
So I guess it depends on 2 things. First of all, your ability to identify which works went into the 99%. Second, the type of license that these companies will receive from author societies. And I believe, again, it's very early days, but I believe that the licenses will have to cover both the ingestion of copyright works into the AI services, but also the output.
Yeah.
They will have to do that. And in that way, it solves the problem.
Thank you.
Thank you. Charlie Phillips, thanks very much indeed for a wonderful lecture, Gadi. I think on a more kind of pragmatic level, the question I have is, to what extent is artificial intelligence or machine learning currently being used in the processing of all this data by collective licensing management organizations, and to what extent that is a threat to the existence of the societies in the same way that it's a threat to the existence of artists and creators?
Yes, thank you, Charlie. So a very good question that unfortunately there's not a lot that I can share publicly, but what I can say is that author societies are now, at least the big ones, are looking into how they can integrate AI solutions into their own operations and into their own processing. One of the areas, for example, that is being looked at is, for those of you who are familiar with the identifiers that are used by the music industry, the ISWC that identifies the composition and the ISRC that identifies the recording. So one of the applications of AI now that is being tested is how we can link between the two of them, because that's been for a long time an issue that the industry is facing and that would benefit from improvements. So I know that some societies are looking at that, and others are just reviewing their whole operations and with the teams checking where they believe that AI can be integrated and help the operations of the societies. But again, it's very early days, but it's definitely going to change also, and AI, I'm sure, will bring a lot of efficiencies in the way societies are operating.
Hi, my name is Paul Crockford. I'm a manager of creatives. I think Crispin and I are probably the only creatives in here. It's very intimidating to be surrounded by a bunch of lawyers and judges, I must say. I don't really have a question, or more a comment, is that I was discussing AI and trying to get an undertaking from a label that my artists' rights in AI would be protected, and if we wanted to opt out, we could. And the comment which came back from the very highly placed executive on one of the major record companies was, this is all too late. That the AI scraping has already gone on, that we're now, as usual in the music business, running to catch up with technology. Legislation is miles behind, and that those to retrospectively go back and try and license the rights that you know, or at least assume have been scraped if you're a major creative, is an almost impossible task. I would also have an issue, because I'm not a big fan of PROs. It's very interesting to me to hear you talk about transparency when you can't even audit a PRO, any PRO in the world. You can't audit as a creative. But that's a conversation for another day.
I'm not sure if it was a question.
It wasn't a question.
Yeah. Well, look, I think that whenever new technology came, we played catch-up. The industry, legislation. Unfortunately, in my view, and again, this is a topic that we can continue discussing for a very long time, this technology moves very fast, much faster than previous technologies. And on the other hand, unfortunately, legislation moves even slower than it used to be. In the 90s, when the internet started developing, in the mid-90s, we already had international treaties to give new communication rights, to protect creators, record labels, and performers against interactive transmissions. I think that anyone who is familiar with the state of international rulemaking today knows that it's impossible to expect, in the current political climate, a new international treaty on AI. So we have to play, to choose the priorities and to lobby at a local level. And a lot is happening in this area, but I think that a lot is happening. I think that the developments in the EU are quite encouraging, but again, as I said, a lot will depend on how it's going to be implemented, and we depend on decision makers to help us because I mentioned it, I think, more than once. It's never easy to negotiate licenses with new technology entities. It's not that we are sending them a letter and they reply with a check.
I've got a question. You're talking about catch-up. I mean, copyright is catch-up law all the time. We didn't have copyright when there was nothing to catch up. And soon as people invented printing presses, then sooner or later copyright had to come. When you've got etchings suddenly, then suddenly you get more. And the 19th century English history is a whole bunch of things, one after the other. Well, I'm reminded of what happened when photography changed in about the 1930s. From the wonderful, great, elaborate cameras with the great plate to the 35mm. And suddenly, photographers did different things. One of the old school said, oh, it's like a herring, lays 2 million eggs and hopes to survive. And to some extent, that's true of images. And is that got a place to be thought about here when you said, well, if there's a little bit of human input, that should be enough. And one of the most biggest human inputs is choosing which one to put forward. In the first place, Cartier-Bresson did not print everything he did. He chose which ones. That was part of the creative process. Is there going to be room in copyright law for choosing being regarded as creative?
It's a very good question. I'm not sure I have a good answer.
We're not going to beat that.
Yeah.
Okay, it's across the road. Badges, please. If you're not coming to the drinks, please leave your badges there. I'm told they cost £1 each.
Thank you.